Hey everyone, good morning. I'm JD Houvener and welcome to the Bold Today show. You've made it to our weekly show. It's a Wednesday morning, 9 a.m. Pacific and noon Eastern. I come on as a patent attorney and owner here at Bold Patents Law Firm, answering questions from entrepreneurs, inventors, people out there just curious about patents and what intellectual property is all about. So you've come to the right place. If it's your first time watching us, give us a like, share this with your folks on social. I want to have this be a vibrant community. Last week we had a great showing, about 15 people, live viewers, and we were able to showcase one of our clients, Inventions. That was great. No guest today, so I'm sorry about that, everybody. I do have an interesting topic today. You probably saw from the title above, Springtime Inventions. As you can see, there's a little bit of sun coming in. Actually, it's a foreign object in the sky up here in Seattle. It is getting bright and spring is around the corner. So I wanted to have that be a topic. But we've got a little twist that you may not be expecting to that subject matter. So before I get started into the subject matter, before we get any live questions, I did want to offer this disclaimer. I'm a patent attorney and absolutely would be happy to have a confidential discussion with you about your invention. This, however, is not the forum for that, okay? This is a public, obviously, it's a live broadcast where we do not want to have you feature any of your confidential subject matter. So please don't, put forward any information about your invention here. This is a place to ask generic questions, hypotheticals. Okay, you can be tricky, or you can be subtle with some of your questions. Hopefully, get some answers from me back. All right, and I will prioritize the live questions. If we don't have any live questions, I will jump to our avlo.com listeners. Some of those people have been asking questions of me as a volunteer attorney around the country, where I help answer questions on IP, specifically patents and trademarks. So that's what we'll be talking about later on today. I want to also give a link to those of you who may be watching now or maybe after the fact that are ready to move forward. I have a link right here for you to schedule a free 30-minute screening session, okay, just to see if patenting is right for you. That's one of the major questions we get from first-time inventors is, gosh, is this really the right thing for me? Do I need to spend a ton of time and money launching into this? So I'm giving away a copy of this book as I do every week, okay? Free PDF download. This is going to give you all the nuts and bolts of how to get started on the patent process. All right. Excellent. Well, let's jump into our program. Our typical format is going to be talking about our subject, our topic of the day, the free offer I just gave for that book, and trying to stay out of the light here. My goodness, spring is coming, but I was trying to play a joke on you guys. All right, I actually have inventions related to spring. Okay, and it's not necessarily the time of year or the season. These are actual springs. So let us venture down that lane here. I'm going to share my screen with you guys. All right. So let's take a look at some of these inventions related to springs. So this first one is it's a handheld device. You guys are probably familiar with mobile phones. I think almost everyone has one of these things. I wanted to showcase some patents that have recently been granted. This one was granted just about 3 months ago in December of last year. Looks like an inventor, John Stage, and they have a company, Scooch LLC. And so there's a spring as a part of this device, and it's a bistable spring for basically a housing. And you kind of see the spring here in a sort of smiley face shape. I believe it's item 136 for this housing, and it allows it to be stable on this particular housing that they've put together. So springs are definitely still very viable, even in today's modern high-tech world. Springs are mechanical, one of the most simple inventions, simple type of concept that I can think of in the mechanical world, and just want to bring this to light, that these are still very viable in today's world. One more example of a spring. This is a transmission. For those of you who may be in the automotive industry, these are still, very, very hot off the presses. And this is just a few months ago, September last year, a brand new clutch. You wouldn't think so, but yeah, there are still new types of transmission clutches being invented. And this one includes a locking torsion spring, okay? And you can take a look at this spring here in the middle. It looks like it's a, reminds me of the dryer vent, when you're trying to hook a hose clamp over. And they've inserted one of these right in between. You can see an exploded view, item 70. And I believe what that main function is to lock in the different components, and perhaps reduces the amount of individual parts that go into making up this clutch plate. Obviously, I haven't done a whole lot of research on this one particularly. I just wanted to point out that you can see in figure 4, this is a spring. This is a type of spring. It's still extremely viable. So even the most simple type of mechanical inventions are still being issued today. And I saw this one. I wanted to make sure I brought it to your attention. You can see that it was developed in China. The CN means it was originally filed in China, overseas. And there's a priority date back in 2018. So they filed it first in China and then filed in the US in 2019. And they got the rights granted soon after. This is a fairly complicated automatic spring fastener assembly machine. So they've got the whole entire machine here. But I thought it was just so amazing that these types of machines, classic industrial type of production machines are still extremely patentable, and you get 20 years of protection if you've got the first of its kind. And last one I wanted to show is pocketed spring pad. This was unbelievable. I thought there's no way there's any way you can create a new type of a bed, right? These springs, the different types of mattresses I've seen advertised since I was a kid and well beyond and well before that. But Jason Jewett out of Carthage, Missouri, who has now assigned his patent to L&P Property Management Company, has invented a new type of spring mattress. Unbelievable, right? So the sort of pocketed springs, which I think I've heard of before, but you can kind of read some of the abstract that there's some very specific language around the way that the fabric is sewn in around each pocket. And they've got this nice 3D model. This was just issued, right? Just granted. The patent office says, yep, as of November 2020, this is the first of its kind, okay? Now, of course, you can't just look at pictures. You've got to go look at the claim language, right? And I talk about this all the time. What they actually own is listed here, okay? And there is actually quite a bit of wording. It's a bedding or seating product. So they actually included not just bedding, but seating. So who knows, chairs or sofa. A pocketed spring assembly comprising a plurality. Plurality is just a fancy word for more than one. Parallel spring, strings of springs. That's kind of a term that they've introduced, strings of springs. Each of said strings being joined at least one adjacent string. So you can kind of read through. I'm not going to read the whole entire claim, but this is what's described in the specification. And apparently, according to the examiners and the U.S. Patent Office, this has never been done before. So you can do it. All right. This is hopefully meant to, in a way, encourage you. Right. If you're out there inventing and you're wondering whether this is the right time for you, and you're not sure whether what you've got is something that's still patentable or viable in the market, I'm showing you some springs. My goodness. And there was like 10 to 20 other results even in the past few months that have been issued. So those are definitely still viable, and please give us an email or shoot us a call if you're ready to get started, okay? All right, so I'm gonna jump to some AVA questions. These come in from around the country. I'm a volunteer attorney, and I'm happy to do these every week. I saw there were a handful of trademark questions, no patent questions this week. So let's take up a few of these trademark application questions, and I'll answer them as best I can. This first question is coming out of Boone, North Carolina. Can I use a national park name in a children's book title? I'm writing a series of children's books about each of our 63 national parks. I've read that I cannot use the trademark NP arrow. Interesting. However, other than that, I'm not certain if I can include the following items in my book. Can I use the national park name in the book title, right? Visit, what is it? Yosemite National Park with grandma and grandpa. 2, can I include a photo that I've taken of the national park entrance sign in my book? The sign does not have the NP arrow emblem on the sign. Well, I think there's a high level of initial, advice here. I think I would want to reach out to each park that you're going to try to cite, especially in the title of the book. you're going to likely want to get, a waiver to be able to use that. Given that they are a government, industry, a government program, federally funded, I would assume that it's just a matter of getting that permission and waiver. They're going to want to make sure the content is not, untruthful, certainly not explicit. That's going to comport with, what's been published and what is known. But I'm not sure. That has not come up. So I think it's a great question. I don't have an excellent answer until until you actually reach out to those government entities to see about using that. I think the main concern is going to be you're going to be using that mark for commercial use. I mean, you're going to be making money off of something that the government's created. So that may be an issue there. That's just my hunch. Okay, so I wouldn't just go out willy-nilly and start publishing that without getting a waiver or a license in place to use that. I'm not sure what NP arrow, National Park arrow, is that the logo? I imagine maybe that's the logo for national parks. Yeah, and so certainly governments can get trademark and even patent protection for inventions and for brands. So you want to make sure you're being careful about that. In terms of the photo, so a photograph is generally, high level, usually subject to copyright. And so if you are the actual photographer, in almost every case, you're going to own what's in that photo. Of course, if you're going to be publishing that photo or selling it for commercial purposes, what is in that photo does come to a head. If you're actually showing a brand, right, or someone else's artwork, let's say if you're taking a photo of the Mona Lisa, right, if that, and certainly that piece of art has copyright protection and has ownership around it, you're not going to want to be able to make, you're not going to be allowed to make revenue or commercial profit on that. So there's kind of multi-layered IP aspects here. I think it'd be wise to seek the advice of counsel. All right, thanks for your question. All right, second question is from Little Rock, Arkansas. My claim for trademarking a basic word or franchise hotel classification could not be challenged by common law trademark. I did not notify the use of the trademarked word already being sold in t-shirt form, only on the application for a restaurant hotel classification. I'm wondering if that will bite me later in the process concerning restaurant expansion into common law areas. Interesting. So, someone may have applied for a trademark for their hotel chain or their hotel classification. I think it's important to kind of differentiate here. Trademark law is put in place to protect the consumer, right? To make sure that someone who purchases goods or services, right, from a hotel, it's going to be someone who's a patron who's looking to stay at a hotel. They need to know if they see a logo or a word mark where basically what the source of those goods are, right? If they see Holiday Inn, you kind of have some already things in your mind about what you're expecting to see. And so you're associating that word mark with the actual company, right? The actual service that's being provided. There is some major confusion that happens a lot. And I think a lot of individual first-time, brand owners think that, oh, I've got to have my brand on a t-shirt. And that's sort of the beginning, okay? And certainly not, okay? The issue with t-shirt designs is that all you would own on the front of the t-shirt, whatever is indicated there, that's artwork, okay? That's whether it spells something out in words or it's just a colorful image or logo, that's a piece of art, okay? And that's governed under copyright law. If you're trying to generate and communicate the brand, where that actual article of clothing came from, that significance will actually be identified on the tag of the shirt, right? The actual manufacturer or the company that's selling the t-shirts. That's where branding comes in. And so certainly in most every case, in this case particularly, you're not going to be able to get protection for restaurants or a hotel if you've only been able to provide evidence that you're selling t-shirts. So I think that hopefully I was able to get to most of the question there. Maybe some other follow-up questions, and feel free to email me later if you do have any of those. Let me just put down my personal contact info in case you guys want to follow up. And I apologize about the lighting. I just got a whole lot more daylight coming through my window than I've had in a long time. So I'll have to adjust that for next time. Okay, so there's my confidential contact information, phone number, and email. All right, you guys, well, no live questions this week. Gotta say, I'm a little bit bummed, but if we have any more come in, I will take those as priority. I'll do one more question out of Avo, and then we'll basically take a break and we'll check in with you guys next week, all right? Let's do one more trademark question, and then we'll let you guys get back to it. Okay, so this is a question out of Victorville, California. If my trademark doesn't get approved for my store, and I've been selling under that name, can I always just rebrand? Okay, this is good. So just in case my trademark doesn't get approved, can I change the name of the company I've been running? Absolutely, absolutely. And you know, it's sometimes not the result that some trademark owners or brands or companies want to face. But if you're open to it, and if there's a direct, prior use of your mark, so some other company or some other entity has already snatched that name up, has been using it in common law, or worst case has a federal trademark registration for the same word or a substantially similar mark, that is really one of the major options, is you get to just change your name, okay? And change the way that you're communicating and change your whole brand to your customer base. While it's not desirable, sometimes is the easiest solution. But there is another alternative, and that is to have a conversation and negotiate seeking a license from that owner of that trademark that is potentially conflicting. So instead of having to change your name, you could potentially work with that trademark owner and say, hey, look, I'd love to be able to use your name. I want to be able to continue doing business under that name. May I do so? And maybe you have some agreement in terms of I believe it's called, sort of a cooperative agreement, where you agree to kind of stay over here, right? Let's say, East Coast, and they're going to be on the West Coast, and you've agreed to that. And in order to make that happen, you've got to pay them, let's say, a royalty for all your sales or some sales, right? That's sort of the case if you've been in business for a number of years and it just finally came up that you're actually infringing. It could be pretty detrimental to have to change your name. So that's definitely an option if it's going to be that painful to change. But if it's early days and you don't think changing is to be that big of a deal for your customer base, then you ought to do that. And before you just pick another new name, okay, hire an attorney and a law firm that can do a thorough trademark search for you to make sure that the new name you're going to be switching to is clear, right? There's going to be no distinction issues, and you'll be able to get a registration on it. All right, well, thank you for that question. All right, well, I'm looking to wrap up. We're going to catch up with you guys next week. Keep those questions coming. I will monitor to see if any follow-ups come on Facebook. I hope you have a wonderful rest of your day. Take care. Go big, go bold.